lawful purpose of the trust. The trust must be created for lawful purpose. That's very clear. The trust cannot be or should not be created for illegal purpose, unlawful purpose. Section 4 provides as well. Then we will see the section now. But trust must be created for any lawful purpose. That's the license given to create a trust for any legal or any lawful purposes. That's fine. The purpose of the trust is lawful unless it is prohibited by law. That's very clear. That's very clear. Then, unless it is of the nature of that, if permitted, it would defeat the provisions of any law. Then the third one, it is fraudulent, then it is unlawful. Then unless it involves or implied injury to the person or property of another person, and unless the court regards it as immoral or opposed to the public policy. Then these are the things defined or given in the trust ordinance in section 4 that is prohibited. You can't make a trust. That's why purpose of the trust is lawful always unless it is prohibited, it is immoral, if it is fraudulent, whatever it is given. Every trust of which the purpose is unlawful is void. If the purpose is unlawful, the trust is void. But there's a small different provision, and where there's a trust created for two purposes, dual purpose, two purposes, then out of which one is lawful, the other one is unlawful. Two purposes cannot be separated, then the whole trust is void. That means if there is a purpose, there are purposes, then they say suppose there are two purposes. One is legal, other one is illegal. But it cannot be separated, then what? But if it is separable, then we can give effect to the legal one and void, the other one, illegal one, is void. That's very clear. The legal and illegal, the lawful purpose. Now come to this case law. In the case of Saroja Nisanchala, the lady who was staying in Dubai, she did not pay any rent to the landlord, stayed there, the accommodation was given to her, but she didn't pay the rent. But she helped to the landlord in cleaning the garden and everything she has done. After some time, the landlord, he is not as long as a Dubai man, he agreed to purchase a land in Sri Lanka in her name. Then he did as he promised or agreed. After some time, he filed an action under law of trust because he purchased, he paid money. The property now with her. I am the one who purchased, but the property with her. Then I don't give the beneficial interest to her. Then I am the owner of the property. Now the trust, it is on trust. Then the lady's argument was property purchase in third party's name in order to evade the payment of tax. Nowadays that the Law Finance Act was amended. Now it is totally prohibited selling the land to the foreigners. At that time, the Finance Act enables to foreigner to purchase a property by paying 100% tax. If the value is 1 million, then tax also another 1 million. Then the foreigner can purchase the land. Now stopped. But forget about that part. Now that's not the issue here. Then in these cases, now he evades the tax, payment of tax. Whether the trust could be created in terms of section 4 and section 98 of the trust ordinance. Section 4 that we have seen. What's the 98? Nothing in this chapter. That's it is under chapter 9. Nothing contained in this chapter shall impair the rights of the transferee in good faith for valuable consideration, or create an obligation in evasion of any law for the time being in force. Then, for the time being, we will take this way. Nothing contained in this chapter shall create an obligation in evasion of any law for the time being. Then when you read section 4 together with section 98, if there is a violation of breach of law, you can't create a trust. But the issue was something different here. What's the different here? This is a revenue law. The Finance Act in the sense, that's a revenue law. Then we will see the court cited L.G.M. Hurey's work. The L.G.M. Hurey, in his work, he cited Professor Veeramandri's book, Law of Contract. The Professor Veeramandri cited jurist Pulak and said that certain things. Now we will see. Mere breach of revenue regulation would not render illegal a contract. That's the Law of Contract book. This is a mere violation or mere breach of regulation. It would not render illegal the contract. Then there is an express prohibition. Express prohibition, then you can't do that. Sometimes it may be express prohibition, but not enough to make the contract illegal. Then in that case, it is not illegal. Because generally when you see these Finance Acts and as well as the Inland Revenue Act, the return should be submitted within the specified time. The tax should be paid within the specified time. If the party or if the person fails to pay within the specified period, then there may be a penalty or surplus, either way. In that case, doesn't mean that it is illegal. It is an offense. It is void. No at all. You have to pay in additional money. Likewise, here also, now the property purchased in lady's name who is a citizen of Sri Lanka. But once, in future, the property transferred to foreigner, then he should pay 100% tax. There is no evasion of tax. Therefore, the court said, there is nothing illegal, even though there is a mere breach of violation of Finance Act. Then further we must see in this place, in addition to these things, we must see section 86. 86 we have already seen in the constructive trust. Here also this is something illegal. But we have seen in section 4, if the purpose is illegal, it is void. If the purpose is illegal, then it is void. Then here we will see where the owner of the property transfers it to another person for illegal purpose. That's very illegal purpose. And such purpose is not carried on into execution, or transferor is not as guilty as transferee. There is a comparison in between transferor and transferee. Transferee is less guilty than the transferor in those circumstances. Or give effect, or the effect of permitting transferor to retain the property might be defeat the provisions of any written law, any law. It may be including customary law. Then unlawful enrichment. If we allow as it is, then somebody getting unlawful enrichment. In those cases, these are the three circumstances. Those cases, then the transferee must hold the property for the benefit of transferor. That's a resulting trust, then as well as we have seen constructive trust. Then here what is happening? Even though the purpose is illegal, but not carried out in execution, there is a comparison between transferor and transferee. And if you allow as it is, it defeats some provisions of law, then there is a trust. Then we can say 86, the provisions of 86 are exceptions to section 4. Likewise 87 also, in the case of testamentary matters. That also, it is for an unlawful purpose, but still that's a last will. Last will comes into operation on the date of death of such person. Therefore, this is also maybe, even though it is for illegal purpose, it may be valid. Then we will see two maxims. Extuberi costa orita action. The meaning is the course of action is defective. Then you can't claim any remedy. The course of action is defective course of action. Then no case at all. The second one is in peri delicto est poiser est conditio defendendis. Both parties are in wrong, then defendant side is stronger. Then in those cases there are some exceptional matters, but for the first one, that's extuberi maxim, there is no exception at all. There is no case at all. But the second one, the defendant status is something stronger. That means there is an exception. You can use certain exception and get some relief. This is the general idea of the lawful purpose of trust. Now in this one also I would like to say, if you want to clarify by way of comment, you can ask any questions that will be answered to you. Thank you very much for watching this.